Are you an active real estate professional? Over the next several videos, I'll be doing a series on basic principles and duties that may be applicable across the United States, but specifically, this series is actually designed for Wisconsin real estate professionals. Let's talk about that. Hello again, I'm attorney Robert Flessis. If you're new to this channel, now is the best time to subscribe because you'll know where to go to get answers to your legal questions. Well, real estate professionals, just like any other profession, are regulated by their respective state. Many of the duties that they must abide by are codified in state statutes or administrative rules. The series that you'll view is geared to Wisconsin real estate professionals again. As a matter of fact, if you're a Wisconsin real estate professional, you have a 2-year window to satisfy your continuing education to maintain your license. All of the videos that you'll view are Wisconsin rules. So if you're a Wisconsin real estate professional seeking your continuing education requirement for the 2023-2024 biennium, I'll post a link below to the official sign-up page for the Wisconsin series that you can use to satisfy your CE obligation. I'm the instructor for both in-person and online teaching in Southeast Wisconsin. The videos that I'll present here are excerpts to the actual online CE courses. This first video will be on the topic of agency law, and I hope you learned something from it. Why are we interested in agency? You're confronted with agency law every day in your real estate career. Understanding agency relationships is critical. You have both legal and ethical issues that you'll be confronted with when dealing with the public in your real estate transactions. Relationships are created in a number of different situations. You create agency with a buyer or seller and a landlord or a tenant. Who you represent and the duties you owe is the whole point of agency. You're representing the interest of a client. Agency law was created to protect the public, and you're required to understand how agency operates. Take the example of a divorce in a legal setting. It's unethical for an attorney to represent both spouses. Now, why is that? It's because both parties have competing interests. How can one attorney give advice to both of the parties when competing interests exist? They can't. The divorcing parties are dividing up assets, possibly dealing with custody and placement issues if they have minor children, and other considerations. The same thing applies to you as a real estate agent. You can't represent the interests of both the seller and a buyer simultaneously, or a landlord and a tenant for that matter. They too have competing interests. Well, here's a simple comparison. Let's analogize agency law to a football game. If all of the players on the field during a game wore the exact same uniform, you would know who's playing for which team, right? As a fan, you'd be confused. And I bet the players would be confused too. That's why we have agency rules in real estate. A lister is wearing one uniform and the buyer's agent is wearing a different uniform. Everyone in the game, or for our purposes, the transaction knows which team each agent is playing for. No more confusion. The point is that we're avoiding conflicts of interest, and by operational law, abiding by the state rules that set forth your duties to the parties.